coming to you live from Annapolis, Maryland. And today's presentation, we have a little different format. We're going to have what I'll call open mic. So kind of pulling that from, I guess, the entertainment section. But I'll be the MC on this. And what we've done is to invite some experts in. So I will introduce myself. I'm Margie Cosmerl. Many of you who are joining us today have attended our other presentations over time. And we are financial planners, Blue Heron Financial Group here in Annapolis, Maryland. We also do a lot of work with Northrop Grumman and have been on their platform as financial planners for 22 years. And so how about we do this? How about we go and just, I'll ask you all to do a quick intro to yourselves. You know the work that you do, and then we'll get into some questions that we've been hearing and direct those out to you all. So why don't we start with you, Bob Callis.
My name is Bob Callis. I'm the owner, funeral director of Callis Funeral Homes and Crematory. We have a location in Edgewater, Maryland and Oxon Hill, Maryland. And we are fifth generation family owned business. Fifth
generation. That's incredible.
Mm-hmm.
Did not know that. Awesome. All right. So Mike or Zoe, who's going to take the lead on the intro?
Ladies first.
I'm Zoe Parasides. I'm an attorney with Sims & Campbell in Annapolis, focusing on estate planning and estate administration. I've been practicing this area of law since 2017. So a little bit of a newbie, but still got some years on me.
Very good.
And I work with Mike.
Where did you go to law school?
Maryland.
All right, go Terps.
Hi, I'm Mike Lair. I'm a partner with Sims & Campbell, law firm here in Annapolis, Maryland, and also in Towson, Maryland. Our firm focuses its entire practice on estate planning, family wealth transfer, and asset protection, as well as estate administration. In plain English, that's helping folks with wills, trusts, powers of attorney, and then helping folks when someone's passed away through navigate the process, the legal and the financial process, coordinating oftentimes with folks like Margie and other bank accounts and so on and so forth.
And thank you. Thank you all for making your own introductions. You know best about your field. But that's a great kickoff. Mike, I'm going to just go right back to that wills and trusts. And if you or Zoe would like to just elaborate on what is the difference when we're making a recommendation for our clients to take care of their estate planning, and they'll say, oh, well, I have a will, or do I have to get a trust? And we, from our side, say, well, that's going to be between you and the attorney to figure out. And we work closely, but we're not going to write the document. So you need to ask that question. So could you tell us more about that difference?
Yeah, first, I think it's a great question. And I think that's great advice, because it's a nuanced question that we spend a lot of time talking with clients about what's the right fit. Fortunately, for those of you that are listening to us that are in Maryland, Maryland's probate process isn't so bad that we feel like everybody has to have a revocable trust. A revocable trust is a common tool that is used to allow families to avoid the probate process. So I'm using a lot of jargon here, and I'm going to try to unpack some of that a bit here. So first, what is probate? Probate is the public administration of someone's final affairs. In other words, after someone's died, if I owned a bank account and a house, and I'm no longer here, someone has to have authority to act with respect to that bank account in that house. And probate's the process that you go about doing that. So probate is admitting a will, or if there is no will, admitting that there is no will. And then the probate court will appoint somebody, you know, basically knight them as the personal representative, which is Maryland and a lot of states' term for executor. And if you die, like the circumstance that I've just brought up with just this bank account and house, as soon as you're named as the executor, the banks and and title companies will allow you to act as though you were the deceased and sell the property or close the account and put it into an estate account. Finally, the next thing that probate does is it allows those people that are owed money by the deceased one last shot to collect from them. And they get a shortened window here in Maryland of 6 months from when someone's passed away to file those claims against the estate.
So I have a quick question, Mike. So are those still where they have to put it like in the newspaper when they, right?
Yeah. So
same process for probably like 200 years or something, right?
Yeah, right. It started with you would post it in the middle of town, right? Hear ye, someone's passed away. But now, you know, if you look in a newspaper, it's on that last page. It says something to that effect, basically. Someone's passed away, Mike Lair's passed away, and Zoe's been named as the personal representative in the estate in Anne Arundel County. And then it'll give some specific legal dates. You know, died on this date, you have 6 months to file a claim from this date, not the notice date, but the date of death. And that public notice is actually what puts the world on notice and allows us to have this 6 month statute of limitations for creditors.
Okay. Yeah, it's really kind of fascinating how the same rules moving forward are still very applicable. So I'm going to segue this over to Bob. So what, you know, we're talking about death and probate and trust, and it's been interesting in our financial planning world how things have evolved over time. I said this earlier before we had the registrants jump on. It's kind of nice to take a little break today from talking about the markets and talking about something else. And not to say that if you have questions about the markets, we can talk about that later. Feel free to email or call. But Bob, back to you. We're finding that this is coming up in conversation with clients more as far as, well, should we prepay on funerals, and what does that look like? And maybe that comes up in your world too, Zoe and Mike, as you're, you know, working towards this estate planning, and how we all work together. So Bob, if you wouldn't mind just sharing with us a bit on what that process might look like, because I think it's kind of an unknown. People don't want to talk about it. Now that's a lot of things in our world, but it is important. And for any of us that, you know, there's a family, there's those considerations. So if you'll just give us some inside information.
Certainly. So a lot of people pre-plan their funerals. So basically the process is you set up an appointment and you come in and we discuss all your options and you make decisions on how you would like things to be handled. And sometimes people choose to prepay that. Sometimes they choose not to. It's really not focusing on the prepayment. As far as I'm concerned, it's more about recording their wishes. We get the information that's eventually going to be used to fill out their death certificate, and we establish a file here at the funeral home. And the theory is that when the death occurs, the survivors know what the deceased wished. The prepayment part of it is available. When someone prepays the funeral in full, we have to take their money and place it in escrow, and we use insurance vehicles to do that. So you prepay and you get an insurance policy, and it doesn't matter your health or age because you're paying for the insurance policy in full. And that money just sits there and earns interest. And our funeral home offers a price guarantee where the guarantee is that no matter how long you live, your survivors will not owe us any more money for that funeral, because we depend on the interest earned to keep up with our price increases. But if that doesn't work out, then the family does not have to make up the shortfall. So some funeral homes offer that, some don't offer the guarantee. Some people choose to prepay, some people don't. But we do a lot of pre-arranging. We probably make as many pre-arrangements as we make actual funeral arrangements in the course of a year. So it's a very popular thing.
Yeah, yeah. Well, and I think it for a variety of reasons, and working with clients as we have over so many years, it alleviates in the midst of grief having to make rash decisions. So just even from that emotional standpoint, it makes sense. And even, bringing it back to overall planning, my gosh, inflation is certainly the topic du jour. And if in this pre-planning process, you can essentially lock in on prices. I did not know about the escrow or the insurance, and that policy is what that helps from.
Well, that's so some funeral homes put the funds into a CD, but you can't just accept the money and put it into your general checking account. You have to place it somewhere that if we went out of business or we sold and the family didn't choose to use us, they would still have their funds. So that's to protect the consumer that you put those funds. We choose insurance because the interest rates are better and any interest earned is not taxable. So the person doesn't get a 1099 every year. So it's to both of our advantage to use an insurance vehicle. So that's what we do.
Yeah.
Bob, do you own the insurance policy, or does the
that's
planner?
A good question, Mike. So the person who made the funeral arrangement owns it, but when the death occurs, we file for the proceeds. The family doesn't have to do anything. We just file, and the insurance company sends us a check, and then we figure out the math whether if we owe them money. So I neglected to say that if there's excess money in the account, that can be returned to the family. So we only keep the interest earned up to the cost of the funeral at the time of death.
Yeah, and it's easy for Bob to say that. As a person who administers estates, I can say for a fact that that does actually happen.
Yeah,
right?
Yeah, it does.
So I'd say it's probably like 50-50 where I see some money coming back to families when they've prepaid for a funeral.
So when a person gets to a point in their life where they're typically, this happens when you're in a facility and you're paying monthly and it's very expensive, at some point you're going to run out of funds. So at that facility, they have caseworkers, and they will tell the person that they are in the asset reduction phase of their life, which means they have to get their assets down to $2,500. And once they do that, then Medicare, I get them confused, but one of them
Medicaid
take over payments.
Right.
You can prepay your funeral and sign a form that says it's irrevocable, and that money is not counted as an asset. So it's like a tax shelter. That is the number one financial reason to come and prepay a funeral. It's to your advantage to use your own money to pay for your own funeral, as opposed to spending down all your money to $2,500 and then leaving your survivors with this funeral expense.
Right.
Yeah.
So
that's really great advice. Probably not so much for the people on this call, but for family members that you might be witnessing this for, where they're spending down their assets. Something that's a good place to park that money is in a prepaid funeral, because somebody's going to have to pay for it.
Yeah, it's literally a tax shelter that you can use to, at the end of the day, you're either going to give that money to the nursing home or you're going to pay for your funeral when you get to that point.
Right.
And we have a lot of people who come in at the end of the month and they got to spend this money, and they make funeral arrangements. And it's a great thing to do. But other than that, whether people prepay the funeral or not, just coming in and talking to us and seeing options, and yeah, I mean, it's not a bad thing to do.
Yeah, no, I definitely, I'm very glad that my parents took care of that, because it does take the onus and decision-making off of myself and my brothers. Yep. And, you know, sure, there's that financial consideration. And as Mike said, for the majority, not all on the call today, there are assets. Either we are working with our clients, or perhaps they're on the call, referred to us to participate in today's and interested in our topic. As we're talking about, I'm going to just take us on a different turn and talk about, really, it is a tie-in, like healthcare directives. Let's talk about that for just a moment. I think what we see sometimes from our seat, we're sitting across from the conference, on the conference room table, and we're asking that question. Okay, since we last talked, have you taken steps towards addressing your estate planning? Well, no, because we can't decide who. My wife wants to name these as beneficiaries, and I'd like to name these as beneficiaries, and we can't get it together. Our position, Liz and I always say, okay, just make the appointment and then start talking through some of this. And it's very important that you have power of attorney and healthcare directives in place. We have seen when they're not. It's not a good situation. Having to get guardianship. Now, I'm talking outside my expertise, but we've experienced from having to work it on the financial investment and planning side. And also, again, making those decisions as power of attorney, if someone has dementia, on things like funeral arrangements and paying bills even. So I just threw a lot out there to you, Zoe and Mike, if you want to just grab some of that and expand on it.
So do you want to talk about the importance of a power of attorney and what happens when you don't have one? I think you most recently helped me with the last case we had like that.
Perfect. Let's go there.
Yeah, so Margie, you touched on it. Basically, the alternative would be having someone file with the court petition to be appointed a guardian. Because without that power of attorney document, assets titled in your name alone, no one can handle those on your behalf. So there's a chance that bills go unpaid, taxes aren't filed, all during this period of time where you're incapacitated and unable to do that for yourself. The guardianship process with the court can take, anywhere from 6 months to a year, and then we're still running into that problem, all the while incurring legal fees and administrative burdens to try and secure that guardianship. So it is a little bit more difficult, and you can just avoid all of that by, getting that document in place and appointing someone, you trust to act on your behalf and step in your shoes financially and make sure, everything's taken care of in the event you're unable to do so for yourself.
I think one of the questions that comes up too from our side is, okay, well, can they just call you and take your money, take my money? I mean, my response is, well, if you have concerns about that, that's probably not your person.
Right.
I mean, hate to be so cut and dry about it, but that's my response often on that.
That's ours too, right? Because a very common first question we ask is, should this be effective immediately or wait until you're incapacitated? And, if that's a concern that this person's going to take your money, my first thought beyond all of this is, well, wouldn't you rather know while you have capacity rather than, when you're no longer able to monitor your accounts? The other thing I don't think Zoe got to mention yet was another question that we had put together here is that not all powers of attorney are created equal, right? very often, I know if I didn't live and breathe in this estate planning world, I would say, okay, I would put it on a list and I'd say power of attorney, check. They're not all created equal. They don't all provide the same level of flexibility. And if you have somebody that you trust implicitly in your family, which many of us do within our family, whether it's our spouse or our children, we really want to give those people every power that I have over myself to make decisions, as though if I'm not able to anymore, to be able to step in and make those decisions for me, because there could be substantial tax savings or there could be catastrophes avoided. Some examples of those are if somebody in my, if I'm planning for my children and one of my children becomes permanently disabled, well, I'd want, and I happen to also be now permanently disabled, I would want someone to be able to amend my estate plan to change the way that disabled child's inheritance was received. And then with respect to tax planning, sometimes it's a matter of creating trusts and making gifts to avoid paying estate taxes or avoid paying income taxes, or to shift who's going to be responsible for different types of taxes. And allowing that level of flexibility is very important, because when you have a family that all gets along, that has a common goal, the only people that are reading those powers of attorney in those moments is the IRS to say, you didn't have the authority to make that transfer or to create that trust or to do this specific type of transaction. And so with all that said, it's important that if you have a good power of attorney person that you trust, that you have a very flexible power of attorney document. I commonly will say to clients, ultimately this isn't Mike Lair's estate plan that we're drafting, it's yours, but I want this to be as broad as you feel comfortable with it being broad. Because at the end of the day, I think everybody on this call or on the panelists are in the peace of mind business, right?
So on that, I just have a quick question. So is durable power of attorney, that's a term, is that what you're describing? Is that a durable power of attorney? Where is durable power of attorney used versus a healthcare power of attorney?
Yeah. Well, I'll let Zoe speak to that because there's in a second. But I guess first I just want to highlight that there's like 3, maybe 4 total documents that we always want to consider, and they are distinct and different. Those are an advance directive for healthcare, which has many different names. Sometimes it goes by healthcare power of attorney, sometimes it goes by living will or healthcare surrogate. We in our office call it an advance directive. And that's going to do 3 things. It's going to appoint a healthcare agent to make healthcare decisions for you in the event you're not able to. It's going to authorize medical institutions to share your HIPAA-protected medical information with the healthcare agent so they can make good decisions. And third, it serves as a living will, which is basically a list of your requests for how you would like artificial life support to be handled in the event you're in an end-of-life situation. Zoe, can you speak to the powers of attorney?
Right. So then in addition to the healthcare powers of attorney, there's the financial powers of attorney. And that's kind of where the durable term would come in, is because it survives your disability. So that, I guess, would be where durable comes in. Although I think healthcare powers of attorney are also durable, technically. Right. But yeah.
Yeah. So the term durable means that it survives incapacity. If it wasn't durable, it wouldn't survive your incapacity, which, most people would be scratching their head saying, why the heck did we even do this in the first place? Right. The other type of power of attorney that is commonly looked at is, so there's non-durable, ones that stop when you become incapacitated. And then there are springing powers of attorney. Those are powers of attorney that only get effect, only have power when you're deemed incapacitated. And a lot of people intuitively think that that's what they would want. The downside of those is that financial institutions frequently will need verification that the person is incapacitated. Well, that's obvious, but they'll need it for future transactions. It's not a one and done ordeal. So first, it's a burden on the front end just to get a couple letters saying that you're incapacitated. And then it can be an ongoing burden. And I can't fault the financial institutions for this, because their job's to keep your money safe, and they are just trying to make sure that the document they're being asked to act under is actually in effect. They just want to document that that's actually in place.
That's bringing me to a question. I'm going to lob this one to you, Bob, as we're thinking about, okay, all these different documents. So with regards to the funeral home, is it true that you notify Social Security, or am I off base on that?
So death certificates, so the funeral home fills out the death certificate, the vital statistics. The doctor fills out the cause of death. And then it's all done electronically now in Maryland. So there's a tab or a button we push that says Social Security number verification, which that tells us that the family gave us the right Social Security number, and that notifies Social Security. But we also give the family phone numbers, or a packet of helpful phone numbers, and one of those is Social Security. So the family should still contact Social Security. Okay. But I guess at the end of the day, if the family doesn't do that, Social Security still knows the person passed, because when we submit the death certificate, we have to hit this button notifying you.
Got it. And on the death certificates, I'm just throwing all these questions out to the panel today that we get asked. And Liz and I sometimes have at least a partial answer, and sometimes we're like, we'll have to get back to you. But on death certificates, now I know what we require, and even that differs between which financial institution we're working with. And some require just a copy, some require an original with a raised seal. In some cases, we can return an original. So is there any, just a general rule of thumb on how many death certificates?
Well, I mean, when I make funeral arrangements, I have a list in my head where I ask, real estate, automobiles, life insurance, pensions, financial institutions. And we go down that list and they tell me how many of each of these they have, and then come up with a number and say, not everyone's going to keep this. Tell me how many you want me to get you. And it's based on the number that we come up with. But, you're right. You don't know until you go through the process who's going to keep it and who isn't. So one bank might say, well, I got to keep your certified copy. Another bank said, I'll just make a Xerox and give you the original back. So it's sort of, there's no real way to determine exactly how many to get. I can say that it used to be very difficult to get additional copies. Nowadays, we probably go to the health department 4 days a week to get death certificates. So if somebody calls us and they need a death certificate, we get them very quickly, because the office is very close to my funeral home. So it's easy for us to go there and get them. So we go a lot of days to the health department.
I'm relieved to know that Bob's alchemy for figuring out how many to get is the same as mine, which is, some do, some don't. And we always include little sticky notes on the top right-hand corner, please return to this address. And, what I find is life insurance companies typically don't return them. Most financial institutions do. Most banks do. Most big banks especially do. I think you might run into some of the smaller community type banks that will want to keep a certified copy. But it's anybody's guess how many you'll need. It's not one for each institution like it used to be. A lot of people will, I sometimes feel bad when people come in with 25 death certificates, and because I know that they paid a lot for those. And I'm also glad to know who to call when a client did their funeral through Bob's office and needs more death certificates, because my experience with calling the number is not positive.
Right.
So
yes.
that's good to know that you have a back channel to get additional.
Yeah, it's very simple. They're very close. I go by there on the way to work every morning. So.
Well, and that was quite a few that you rattled off so quickly. Again, I know what the couple that we'll need here, but those were a lot of other entities that are also looking for them. So I might have to come back to that as a follow-up for a list, just so that we're aware too from our side.
Yeah, and let me hit the dead horse one more time, which is ask for them to send it back, because they won't do it if you don't ask. But we're pretty solid on getting them back when we ask. So, you know, we get away with a lot of times clients only getting 5 or 6 death certificates.
and they are, so in Anne Arundel County, the first death certificate's $18, the additional are $20. So they're basically $20 a piece. So they're not inexpensive. So you don't just want to say, get me 20 of them if you only need 5.
Right.
So your funeral director should go through this with you and explain the process.
Yeah, good.
Get the proper.
Yeah. It's some of that information, again, that, you know, we kind of feel like we should know, but we don't unless we ask. And that's what today's about. So as we're talking about logistics, I'm going to just throw out some logistics. I think, Mike, you and Zoe had shared this with me, but I want to throw this out there. Once again, we do have clients who have safety deposit boxes, and we all live in an electronic world, and we have. So things like passwords and, you know, with the evolution of this electronic technological world, can you give us some advice on things that we need to be aware of? I'll just leave that open.
Yeah. So I'm going to talk out of 2 sides of my mouth for a second here, despite being recorded. One is that, you know, the very common practice of everyone having like I wish I had my dad's with me, but a legal pad or some sort of piece of paper with every password that you have on it is very common that people use those, whether it's the power of attorney or the executor. But Margie knows, and I know, that that's not supposed to happen. When you log into those, you're certifying that you are the person that you're going into. So so that isn't supposed to be the way that people do it. The supposed to be way is and the best way to do it officially is actually working with Google or Facebook or whomever it is that has this digital property that you want access to, and accessing their legacy options. They're not always easy to find, but if you Google or search for, you know, whatever the electronic entity is plus, you know, death, you'll get put into the right area. And that's the easiest and best way to do it. Because short of that, there are Maryland laws that exist that allow access to digital assets. But I can tell you from experience that Apple and Google make it very challenging. They require court orders and specific petitions in specific formats, and specific court orders in specific formats. So if you don't even get the court to sign the right one, they'll make you go back and say, well, actually Apple needed this one, which can be costly. So I strongly encourage you to look into that, which is, you know, generally legacy is the name of it. But that's the best way to do it. And it's the official way to do it. Using people's passwords is problematic because when the institution finds out that someone's incapacitated or they've passed away, they will shut off access. And then you're left with going through the courts. And you might have a bit of an uphill battle if they know you've been logging in since after the death, because they know these things. So
yeah, that's really interesting and very helpful. So I'm hearing you say you need to, I think in terms of beneficiary forms, maybe that's not really the direction. However, it's doing it in advance. So you're going into these legacy places on these in advance and naming somebody?
Yep. Yep. So you would go in, it's actually your example of beneficiary forms is spot on. It's basically the same sort of thing. You're naming who the authorized person is that can use these files. You'll also learn a lot about what you are actually paying for through Apple or Google. Do you actually own the photos? Do you own the music? Do you own the videos? Or do you just have a license to the music and the videos, or a license to your photos that you took? So the difference is that Google or the organization might own the property rights to it, and the license dies with you. So you know, make sure you look into that and that you feel comfortable with the way it's set up.
Yeah, that's extremely helpful. I'm taking notes and learning from you all. Bob, we're going to switch it back to the funeral side of things. And again, just observation from our side, maybe true, maybe not. Are we seeing more in the direction of cremation in today's world as opposed to the elaborate, you know, coffin burial and all of that? I mean, is there a trend that's evolved?
Well, so cremation is definitely on the upswing. More and more people are being cremated. That being said, you know, cremation, whether you're cremated or buried, really doesn't impact your funeral. So, you know, people still have traditional funerals. They have viewings. We take the person to church, and then instead of going to a cemetery, we bring them back here to the funeral home and perform the cremation. So that's sort of a fallacy that people think if you're going to be cremated, you can't have a funeral. But that being said, yeah, I mean, I don't think cremation is going away. The funeral industry as a whole, you're seeing less and less traditional funerals. There was a recent article in the Washington Post that stated that for the first time since they've been keeping records, less than half the population of the United States attends church. So funerals have historically been a religious event. And without the religious aspect, funerals maybe don't have a whole lot of meaning for people. So we're seeing less and less traditional funerals. And that's a challenge in my business, is how do we make funerals meaningful for people who don't see any value in the religious aspect of it. So I think going forward, that's our challenge as a funeral home, is to make these things meaningful for people. We see value in funerals. It may not be the traditional way of doing it, but you know, we're very flexible. And like when people come in pre-planned, we have no idea what they were going to want to do. I mean, some people have viewings, some people don't. Some people go to church, some people go to cemetery. It used to be cut and dried. Everybody had a viewing, everybody had a funeral, and we had a burial. But yeah, cremation is not going away.
Yeah, and when you and I had spoken before, it was just about, you know, making it personal. And when you're sitting down with a client and you're asking those questions, what songs, what hymns, what prayers, what verses.
Yeah.
And personally speaking, I don't know that my kids would be picking out the same music as I might pick out.
Well, and I guess that brings up a good point too. So these folks who come in and pre-plan, one of my suggestions is that before you make final decisions, you should talk to your survivors about what you're planning to do, because, you know, the funeral's about the deceased, but it's not for the deceased, it's for the living. So you know, I have older folks who come in and they say, well, we're not going to do anything. So let's just do this basic thing. And then the death occurs and the kids are like, what do you mean we're not having a funeral? I don't want to do this. So then it becomes an issue. Are we having a funeral? Are we not having a funeral? And I guess the person who made the pre-arrangement didn't accomplish what they wanted to, because it didn't alleviate any stress. It actually caused stress. So, you know, it's a whole new thing with people coming in and planning their own funerals. Historically, that didn't happen. They just left it to the survivors. So yeah, the suggestion is talk to your family before you're making any of those decisions, just to make sure they're on board and they know what you're doing, because, you know, doing nothing might not be what the kids want.
Thank you, Bob. And I know we can all relate to this whole discussion about multi-generational planning, really. It has, well, you know, when we think about parents or grandparents, and I'll speak to the financial side of things, it was always a close kept secret what financial position they were even in. And we still see it today. I'm thinking of a client whose mother had come to live with them, and then come to find out later that there really was that stock certificate, CSX, as I recall, a big railroad company, worth a couple $100,000. So those stories are real, but I want to circle back to, we, again, sitting in our seat, financial planners, looking at the assets of our clients, and now clients are aging. We don't insist to the point of being rude about it, but highly recommend that we start having these conversations with the next generation. They are likely to be recipients of wealth. And then that brings in the estate planning side. Are, you know, Susie and Joe, are they responsible? Are there issues we need to address? How can that be addressed? And again, Zoe and Mike, we put this in your lap. If there's concerns about an adult spendthrift child as opposed to the other adult child who is responsible, and every case is different. We totally understand that. But it does take some additional planning, right? So what would that look like?
Yeah. I think first we're exploring it with them. And oftentimes it's with you, Margie, first. Like you know better than we do, because you've been working with the family. It's not the first time you've heard about little Bobby or little Susie, whereas it is for us the first time that we've heard of them. So it's helpful to prospective estate planning clients that you authorize your financial person to talk to your estate planning attorney and kind of give them the background, because we speak a very similar language in terms of setting these things up. And it can save a lot of spinning in circles for the lawyer and you, because they may have already kind of whittled down the options. But oftentimes, two things we come across where we have somebody who's a spendthrift, there's generally two approaches that families take, which is we've done everything we could, and we worked hard for this money, but it ultimately needs to go somewhere, and I don't want to treat my kids differently. So it's sad to know that a third of this is just going to disappear, but it is what it is. Others will use another tool on the estate planning tool belt called an irrevocable trust. And an irrevocable trust is a way where you can set apart the third, in this instance, because I guess I'm visioning this being my 3 kids, but a third to the child to be held in trust for the child's benefit. And since we don't trust the child's judgment in terms of managing their finances or managing their cash flow, you name a third party to serve as the trustee. And there's generally 3 categories of people to choose from, or 3 categories of things to choose from that can be trustee. Individuals, friends and family. So those are nice because they tend to be free. They don't charge anything, though they probably should. And they have a lot of context with the child. The downside of that is that it can disrupt family relationships or friendships or what have you. So, a lot of times people want to name one sibling to another, and I, as a rule, don't allow that. And to the point of, Margie, I'm gonna borrow your phrase, to the point of being rude, because I've seen it too many times. It's batting 100% or 1,000 in every instance where a sibling is serving as trustee for another sibling. Their relationship is irreparable. It's awful. Nobody's happy. The trustee brother feels like or sister feels like they're doing their best, but their sibling hates them, and they're just trying to honor what dad did.
Yeah, that could get sticky. I could certainly see that.
Well, a trustee's job's to say no, right? I mean, that's the, right. And it's a hard thing for someone to say when they view it as being their money.
Now, would a special needs trust be a bit of an exception in that case?
Yeah, and thank you for bringing that up. Yeah, so that I would carve that out, and they're not part of my 1,000 batting average that I was referring to. The two other options are a corporate entity. So, I don't know if LPL or has an affiliated trustee, but there's a number of different corporate trustees that exist out there. And local banks oftentimes have trust departments. They can serve as trustee and are good choices when there is a problematic beneficiary, because they have their process and they don't deviate from it. And the beneficiary either gets in line or they are going to be endlessly frustrated.
Yeah, and we do, by the way, have a trust department through LPL.
Okay, so, good.
Thankfully, we haven't had to run into that.
Yeah. But
occasionally we will have a client who says, I don't know who to name for I don't have kids. I don't have a sibling. I don't have that person. So that is when a trust department would come in?
Yeah, those can be a good option there. Trust departments are going to charge for their services. But that can be good because, well, not the charging part, but the fact that you'll have a relationship with somebody over a period of time, and they'll develop that context that I was referring to. Margie, a common question we get is, I want to name Margie or I want to name Liz as trustee. Can you serve as trustee?
Yeah, we can't.
There it is.
I've had the question from clients as well. So it's been that same answer for 25 years. I've had Blue Heron Financial Group, and I was certainly, I appreciated the thought, the trust that when this comes up and a client says, well, I'd like to name you as a trustee, and we're like, can't do it, which is totally understandable.
Right. And the reason they can't is because there'd be a conflict of interest. Exactly. Ultimately, the trustee's job is to hire someone like Margie to manage the assets. Exactly. So the third option for picking a trustee, so to recap, friends and family, corporate, and the third is professionals. So that's people like us and CPAs a lot of times will serve as trustee. Again, we charge for our services like a trust department does. And the benefit, I'd say, of an attorney or a CPA is the relationship aspect. I think that they can be a better fit for beneficiaries that there's hope for in terms of growing in terms of growing in their financial maturity. Mm-hmm. Because they can be a much more human feel to the way that the trust would be administered. Attorneys and CPAs serve as good trustees when we don't have a spendthrift too, but that's a totally different topic than what we were just addressing. So picking the right third-party trustee is critical, because the trust document is intentionally going to be drawn up vaguely. And that's so that the person writing it, you, can instruct your trustees outside of the legal document on how you want the trust to be administered, and not to give leverage to the beneficiary who you're trying to protect from themselves within the document itself. So common request is that people will say, well, I'd like to reward certain behaviors, right? I'd like to give them a bonus if I'd like to double their salary, or I'd like to bonus them if they go graduate from this or they do that. And all those sound really great, but what I find is it kind of creates this soda machine mentality. People are doing things for the wrong reasons, right? If I press this button, out comes $25,000. Well, yeah, but now you just got a degree that you don't care about. Or if it's doubling the salary, well, maybe this person would have been a fantastic police officer or firefighter or teacher, but the offer was too good to just take a job that could make double that amount of money, and which meant now quadruple that amount of money. So it can sometimes provide bad incentives. What I'd rather see is a letter to the trustee or the trust department that says, these are the behaviors I want to reward, but I want them to be earnest.
Mm-hmm. Yeah, we'll sometimes, on the letters, I've even said to my dad, okay, well, my brother so-and-so borrowed money that didn't get repaid, and you're trying to make things equitable, then perhaps you write the letter, Dad, and in your own hand. So whether that's right or wrong, I just kind of throw that out there. And, all that we're talking about today, I know we could go in like lots of different directions. And I want to give everybody a chance to bring up some things that are forefront in your minds, maybe mistakes that could be avoided. If we could just spend a few more minutes. I want to be courteous to everyone who's online with us, and thank you for your time. And hopefully you're going to, whether you're at your desk or wherever on a phone, but that you've learned something. That's always our goal here at Blue Heron Financial Group with these educational forums. And we'll follow up with each and every one with some feedback too. So who wants to go first? Any volunteers? What's a mistake you've seen happen that perhaps could be avoided by, and then I'll throw that out there.
Well, I have a question for Michael and Zoe, because this is what I run into is with powers of attorney. Do those cease at death?
Great question, Bob.
Go ahead, Zoe.
Yes.
Thank
So, yeah, in Maryland, they cease at death. In some states, they allow for some like post-death activities. So you might, and I think they're specifically geared to allow people to work with funeral directors in other states. That's what I've gleaned from documents I've seen in the past. But Maryland doesn't have that.
So any power of attorney that somebody brings to the funeral home and it says, now this might not even be a power of attorney, but they bring us documents that say, they're responsible for handling their funeral arrangements, even if that's not the next of kin who, let me go back, in Maryland, the next of kin is responsible for handling funeral arrangements. If they have a power of attorney that says it's somebody other than the next of kin, should we follow that, or should we go to the next of kin, or is that a lawsuit?
I think you were describing a lawsuit. And off the top of my head, I don't know the answer. My recollection is exactly like what you just said, which is next of kin has priority. However, I think it can be changed to somebody else with a document, but I don't remember what that documentation is off the top of my head.
Yeah, because the power, people get these powers of attorney and they come in and they say, well, this, I got the power of attorney. And we're like, well, most of them don't say anything about that person making funeral arrangements.
They might be able to pre-arrange for it, but not.
Yes, they can come in and sign a contract while the person's living.
Right.
But once a death occurs, that
there's
power of attorney really doesn't mean anything?
That's correct. It doesn't mean anything.
Okay.
There is a very strange dichotomy that exists when someone passes away because the executor or personal representative is ultimately responsible for paying bills, including the funeral bill.
Right.
But like you said, next of kin, which is the heirs, are the ones that inherit the body immediately. So sorry, I don't have an answer for that question.
No, it's always, so you were saying what's a problem we run into? This is a problem we run into, and especially with cremation. So if someone's going to be cremated, we have to get, say it's the last surviving spouse, well then the next of kin class is the children. And if there's 4 children, we have to get 3 of them to sign a cremation authorization. And that involves, they're all over the country. So you're emailing and getting, it's got to be notarized. And
oh my gosh.
You just run into all these legal issues, and somebody always walks in with the power of attorney, and we're like, well, that ceases at death. And I just want to make sure.
No, you're giving good advice, and you're protecting yourself.
Yes, thank you. Thank you.
Well, and it makes the case again for that pre-planning. It takes that out of it.
So a person who's going to be cremated, they can come in and sign their own cremation authorization, and then that is legally binding. Then we don't have to get the next of kin involved if the person signs their own.
Right. So, when emotions are running rampant.
Right.
Yeah.
So thank you, Michael.
Yeah. I hope that helped.
It did.
The one thing I would add, well, one is we give people just this quick, like 1-page funeral planning sheet. And I always just tell people, you probably don't have like positive thoughts, meaning like, this is what I want to happen. But you might go to funerals where you're like, I definitely don't want this to happen. So writing those down can be incredibly helpful in helping kind of the family plan. Well, it at least even just gets the conversation going. Well, we know she didn't want Amazing Grace played, or whatever the case may be.
Right.
But my advice about avoiding something would be, be careful of anyone that says that you absolutely need a trust without asking questions. We started off the conversation today talking about this, and there's too much nuance to just dive right into it. But in short, that probate process I described here in Maryland is not terribly difficult. There's even an agency that helps families administer estates here in Maryland called the Register of Wills. That's not the case in every state. In a lot of states, probate is hugely difficult. Very obtuse, like not intuitive, and time consuming, as well as, if you hire an attorney, expensive. That's not the case here in Maryland. Some factors that lead us attorneys here in Maryland to saying you should have a revocable trust is if you value privacy, because it keeps things private. If you have a small business, again, probably lends towards the privacy, and you want to keep that information private, having a revocable trust is smart. If you have real estate in more than one state, it's important to consider a revocable trust, because when you die with real estate in more than one state, you actually would have to have a probate administration in each of those states. Maryland's, if this is where you live primarily, would be the primary one, but we'd have ancillary probates in all these other states. And those get very costly. So the cost of setting up a revocable trust on the front end greatly saves the family a lot of money in those instances. But so back to what I was saying at the beginning, be careful of anybody that says, oh, you have to have a trust without them knowing anything, because they need the context to give that advice to you. Right. Trusts trust plans cost more for us to put together. So I think that's why there are people out there that do that. And if you Google, do I need a trust? You'll find plenty of people that say yes. But that's, I think that that's the reason why I push back hard on that, is that I don't want to be somebody like that. I want to be someone that listens and make sure that you're not overspending for something that's not going to provide you and your family value.
Yeah, that's great. And this has been a terrific session. I would love to just talk for another hour because I have lots of other questions that come out of statements that are made. So I will be following up with you all. But we do have out-of-state people on the call, and Mike made a very good point. You know, we can serve in each of our capacities, perhaps out of state, but in state, Maryland. I think that's a very good point. The probate's not a bad word. It's not necessarily an awful thing. And I think just, again, I want to thank you all for your time. I know how busy you are. I know how busy everyone is. And this is important. Everyone here on the panel, we're all about that peace of mind in our various capacities. And I'm just grateful that we could grab this hour together. And feel free to reach out to Blue Heron Financial Group for those of you who are on the call and on the Zoom. And we look forward to hearing from you. Bob, Zoe, and Mike, I really appreciate your time. And I've learned a lot. So thank you. I enjoy working with each and every one of you.
Thank you, Margie.
Thank you, Margie. I really appreciate the opportunity to talk with everyone. Have a great day.
Ditto.
Have a good day. Enjoy the sunshine.
Thank you.
Bye-bye.